This is Radio 97. Well, she's got her textbooks and all her case law, and she's got her briefcase stuffed full of papers, and she's with us this morning, our resident lawyer, Despina Priala from boutique law firm Priala Legal in Runaway Bay, with us every Thursday to offer her legal expertise by providing some general advice on the latest hot topics. She has more than 25 years' experience in the areas of property law and commercial law. She also prepares wills as part of estate planning, litigation, and a whole stack more. Morning, Despina.
Good morning, Wayne. Good morning, Brooke.
Good morning, Despina. So today, to kick off the show, we're going to answer a very interesting question thanks to a lovely listener who got in touch, and it's all to do with body corporate. His question was, can you change your own lock of your apartment without body corporate consent? Is the front door common property or not? Such a good question.
Yep.
Because I don't know, I've never thought of it. Immediately I assumed that I buy my apartment, that's my door. But Despina, it's not clear and simple in this case, is it?
No, it wasn't. And Chris reached out to me recently. Hi, Chris, if you're listening, I'm sure you are. But he reached out to me recently because he had a problem in relation to this very issue, and a dispute with the body corporate ensued because what they did was change the locks of their own apartment, and the body corporate said, well, hang on, you can't do that. You need to get our consent. And a dispute arose and continued, and he reached out to me for some assistance with him dealing with the body corporate. And I dare say this is probably an issue that other people have come across in body corporate situations on the Gold Coast in Queensland. So I thought I'd mention it for those listeners out there and perhaps help them if they're in the same situation.
Yeah, for sure. Obviously, the issue arose because he found out that there was this master key system. Is that correct?
Well, look, there's a few issues to talk about, but that's one of them, yes. So when he came to me and told me about this problem he's having, and look, he had his own reasons why they wanted to change the lock, and there could be a variety of reasons why an apartment owner wanted to change the lock so it's not under a master key system throughout a building for extra security purposes, for other reasons. Maybe the person that lives there has a disability, so they need to use a different locking mechanism for the apartment for themselves. So when he came to me, I said to him, the very first thing we need to do is look at the bylaws, because the body corporate is guided by and must follow the bylaws that are part of the building. So that is the first step you need to do. Now, in saying that, there are bylaws that have been written previously where those bylaws are found to be unreasonable or invalid, so they don't actually comply with the law. Funnily enough, it has happened. So we had a look at the bylaws, and the bylaws actually helped in that there wasn't a very strict rule about lot owners having to get body corporate consent specifically. So it's an interesting case to mention because that particular person, Chris, and other people might not be aware, you need to go to the bylaw first, and you need to look at the bylaw and see specifically what it says, and then you need to go to the Act and cases. And this is the next step that I did for Chris. So then we started to look at some relevant case law because, as I said, I'm sure this has been an issue that's been raised before where there has been disputes along these lines with body corporates in the past. So on that point, I did find a very interesting case to help Chris. And I gave that to Chris, and I wanted to talk about this case this morning because it involved a body corporate on the Gold Coast called Hedges 252. So, and there was a building on Hedges Avenue that had this issue arise back in June 2014. So in June 2014, the case went to the Queensland Body Corporate and Community Management Commissioner, and there were adjudication orders made. And the adjudication orders were in favour of the lot owner. So what I want to do is talk about some of the practical aspects and some of the things that the adjudicator mentioned in this case that undoubtedly will help people in this situation.
So obviously, as you say, this has happened before and it will happen again. And what I find interesting is obviously with bylaws varying between buildings, it really does depend where you live, which apartment block you live in, as to whether some of these issues you'll come up against at some point.
Exactly. So in this case, Hedges 252, that was decided in June 2014, their bylaw, for example, said this, that an owner or occupier of a lot must not alter, adjust, change, rekey, or replace any community door lock without the prior written consent of the body corporate. Now, people might think, okay, there's a bylaw. Obviously, I can't do or change my locks. Well, no, not necessarily. So what happened in this case, there was no definition of that reference community door lock in the bylaws. And in the relevant legislation, the Body Corporate and Community Management Act in Queensland, there is no definition of community door lock either. So they had to discuss that. And the adjudicator wasn't convinced that a community door lock means a door that you use to gain entry to a private individual's apartment.
Yeah.
No.
Yeah, because community door lock implies that it's a door that gains entry to community areas,
the swimming pool
facilities,
or
downstairs,
downstairs reception. Yeah.
Exactly right. So that didn't fare very favourably for the body corporate because the adjudicator wasn't convinced. But also the other interesting thing that the adjudicator said here, you see, is that the adjudicator felt that an owner of an apartment does have and should have the sole control of what type of lock that they have in their apartments. And he was satisfied that it was reasonable for owners to want a lock that is unique to their unit to ensure the appropriate protection of their property, which is actually a really significant point. And this would be a very good case, as I said, for other listeners out there who might be in similar situations that may be able to use this case to assist them. But as I said, look, it turns on the individual facts of the case as always. But when you are in a dispute with a body corporate, you first have to look at your bylaws. Don't always believe that the bylaw is actually a reasonable bylaw or a valid bylaw. And that's really significant to remember. And body corporates always have to act reasonably. That's the other thing that people need to know. So the relevant act in Queensland, as I mentioned before, there are two sections in that act, sections 94 and sections 100. So in those sections, it talks about the body corporate having to act reasonably when it makes decisions. So there's a body corporate committee, and the committee, got certain duties, and they try and carry them out, but they've got to do it reasonably. There are a lot of other things that body corporates can do when they're in the situation to make sure they are acting reasonably. For example, get legal advice externally. Are they acting reasonably before they have to go to an adjudicator and incur costs? And the other tip to give listeners is if the body corporate comes back to you and argues that your lock has to be under a master key system because of emergency situations, in this case, the adjudicator actually didn't agree because the adjudicator talked about other measures that body corporates can take in an emergency. For example, calling fire services an emergency to gain access and entry to your unit in case of emergency situations. So there are other measures that a body corporate can take, and you don't have to be forced to be in a master key system. So there's lots of things that can be done to try and resolve matters, but this case is a really, really important case for people out there like Chris, who's in the situation where they want to go change their locks. Body corporate says no. You go, well, hang on, it's my apartment, my right. I don't want to be part of a master key system in a building, because that itself also has security issues. Yep. And in this case, the adjudicator actually said that. The adjudicator said, look, I've got concerns with people having to be forced to be in a master key system in a building, because that of itself puts all the lots at risk of security issues.
Yeah, sure. And that case there that you found from 2014, Despina, if anyone is listening and did want to take a look, they could get in touch with you.
I'm happy to give anyone who reaches out to me the case reference and even a copy of the case. So it's just sending them the link And there you go. I'm happy to do that.
Easy peasy, awesome. That is Despina Priala there from boutique law firm Priala Legal. And coming up next, Despina's going to share all her secrets about creating a will. She's got 7 simple steps that we can follow if you haven't started your will or want to get one started. It's a little bit daunting, but we're going to try and make it easy and simple for you here on Talking Law. That is coming up next on Radio 97.